she's so fine. Hell of a ride, blows my mind. Hell of a ride, lights my day.
What's good, guys? Today is Saturday, March the 27th, 2021. This video is going to be regarding the Kenneka Jenkins case, and specifically the lawsuit that was filed by her mother, Teresa Martin, as special administratrix for Kenneka Jenkins deceased. Now, this case was filed on December the 11th, 2018. It was filed in the Cook County Circuit Court Clerk's Office, and the case number is 2018-L-013273. Now, Teresa Martin in this case is being represented by Filipovic Milica, who is from Jeffrey Feiger's office out of Southfield, Michigan. The lawsuit was filed against Capital Security Investigations, CPO Hospitality, Crown Plaza Chicago O'Hare, F&F Realty Ltd., NBC Rosemont LLC, doing business as Murray Brothers Caddyshack. Now, there's been a lot of rumors that have circulated regarding this lawsuit. This lawsuit is ongoing. This lawsuit has not been settled. It has been ongoing since the initial complaint was filed on December the 11th of 2018. And it's going to continue to be ongoing for quite a while, in my personal opinion. Now, I'm not going to back everything up. I've done several videos regarding updates on this case. I'm just going to take it back a couple of steps and then put us where we're at now in the case. On November the 10th, 2020, Teresa Martin, by and through her attorneys as special administratrix for the estate of Kenneka Jenkins, filed a request. It doesn't say what type of request. It's very generic. It just says request filed. Now, where we're at now is on March the 5th of 2021. Teresa Martin, by and through her counsel, her attorneys, have filed interrogatories. And that, to me, is one of the more exciting parts of the lawsuit. Because what the interrogatories are a set of questions that Teresa Martin and her attorneys came up with to give over to all of these defendants for them to answer. And it'll be in the form of a paper, and it'll be very thick, probably. Have minty questions in there of everything that they want to know regarding that night in September of 2017 and anything else they may want to know. And the defendants have a set amount of time within which to answer these questions. The clock is ticking, and it's been ticking since these were filed on March the 5th, 2021. Now, I found this website to be rather helpful in explaining what these interrogatories are really looking for or geared towards. It says, in all wrongful death cases, at least one witness to the event is deceased, and that would be Kenneka Jenkins in this case. In many cases, several parties are deceased, and substantial questions can exist as to the accident causation. It can be very important to determine whether a third party investigated the accident. The interrogatories require the deponent to set forth all facts, witnesses, and documents relating to any investigation. Frequently, questions of this nature will be met with an overbroad assertion of work product privilege, so careful distinction should be made between an investigation conducted for the opposing parties, business purposes, or insurance renewal, and those conducted by counsel in preparation for litigation. Witnesses. Since the decedent obviously cannot testify about what happened, witness testimony can be critical in wrongful death cases. The interrogatories set forth seek to discover the identity of and knowledge possessed by any witness to the subject accident. You should include these interrogatories in virtually every set, including the closing set sent shortly before the discovery cutoff. So what they're wanting to know is, were there any witnesses? Did anybody see Kenneka walking through the hotel? That type of thing. Insurance. And I've mentioned this before because it's always thrown me for a loop because they never named their insurance carrier in the lawsuit. And that kind of was a little strange to me because the insurance company would essentially be the ones that would be paying the claim out. It is obviously important that you be aware of the existence and limits of any applicable insurance coverage. Most states hold that the insurance policies themselves are discoverable, which means they can get their hands on the insurance policy. And your knowledge of the policy limits will allow you to make a reasonable decision regarding any settlement offer. So in other words, they want to know what's within those settlement. They can't make a settlement offer until they see what is covered by the insurance company as far as monetary wise. The existence of a coverage dispute is information that you need to have in making your settlement decision, because in some cases an offer of settlement is made so that the carrier may avoid the cost and expense necessary to litigate the coverage question. This can sometimes be a bona fide reason for settlement, since a coverage question may be resolved against the insured, which in turn leaves the claimant without resort to an existing policy. It says the interrogatories or questions set forth are designed to explore these issues. Now, another important part of the interrogatories. It says the first purpose of the interrogatories is to reveal the defendant's contentions regarding how the incident occurred. The answers will also reveal any claim of contributory or third-party negligence, along with any facts or writings supporting these contentions. It is especially important that you learn whether the defendant believes that a third party was concurrently negligent, so that you can ascertain that all appropriate defendants are joined in the action. This may also control apportionment of liability where apportionment is required. Now, what that means is they probably, my guess would be that Crown Plaza is going to blame Murray Brothers Caddyshack regarding the construction area of the kitchen or what have you. And they're going to be pointing fingers back and forth on who was negligent in regards to that. And what that will do is, being that they have so many people named as defendants, they may assign, say, 25% of the settlement must be paid by Murray Brothers Caddyshack, and 25% must be paid by Crown Plaza, and they may split it up like that. Now, ownership and maintenance of premises. The interrogatories set forth should be used to determine the appropriate parties to the case. In many cases involving business premises, the apparent owner is merely a lessee, which is the case here, and the later identification of the actual owner requires an amendment of your pleadings. The questions also require the identification of those responsible for maintenance and repair of the premises. So they want to know who was responsible for the upkeep and maintenance and repair of things that went wrong within the Crown Plaza. This is another important part. The interrogatories are designed to reveal whether the owner of the premises is a corporation, partnership, or other. This is important also, again, regarding settlement and their liability in that settlement. Knowledge of dangerous condition. That's crucial in this case. The wrongful death plaintiff, that would be Miss Teresa Martin, must establish actual or constructive knowledge of the defective condition in order to recover. Which means that she has to prove, or by and through her attorneys, that there was something wrong on the premises of the Crown Plaza. The purposes of the interrogatories or questions is to determine whether the defendant had such knowledge to identify all relevant facts, witnesses, and documents, and to otherwise establish the degree of notice the defendant possessed. It will identify any further discovery required on the notice issue, and a required admission of notice in response to these questions can also enhance the settlement prospects. Now, inherent dangers and imputed notice. The defendant will deny notice of any dangerous conditions, particularly if there are no other witnesses on the notice issue. The plaintiff can still prevail in these cases if it can be established that some aspect of the premises or the business conducted thereon posed an inherent risk of injury. If the defendant denies an inherent danger, which would be obvious to others, the jury will disbelieve defendant. If defendant acknowledges an inherent danger, then defendant must address the question of what steps were taken to warn the plaintiff's decedent. So what steps were taken to warn Kenneka Jenkins? Subsequent repairs. Many states refuse to admit evidence of subsequent repairs as implied admissions of negligence on policy grounds. For example, if they knew that the construction area in the kitchen was unsafe, and after Kenneka Jenkins' death, took steps to repair whatever it was, whatever it may have been, it says many states refuse to admit that evidence. Okay, so that's not a great thing. And it says, for this reason, many attorneys do not inquire about subsequent repairs. But it says this can be a mistake. Defendant plainly has notice of the dangerous condition at the time the repairs are made. So in other words, they were made aware that there was a problem in that kitchen. If that's the route they're going to take with this lawsuit, is wrongful death based on negligence on the part of the Crown Plaza, which is what they're doing, then that could be a big thing. The fact of subsequent repairs can open the door to inquiries about when the repairs were ordered and why. Why were they made? The interrogatories or questions are therefore reasonably calculated to lead to admissible evidence. You should not assume that any repair that occurs after an accident was prompted by the accident itself. If you can establish that the need for repair was appreciated prior to the occurrence, this evidence establishes the requisite notice of the defect. It goes on to talk about the inspection of the premises. Another reason for asking them questions. It says many injury and death cases occur on business premises, so there is a duty on the part of the landowner to inspect for dangerous conditions. That's where F&F Realty comes in. If that is their property, it was their responsibility to inspect that business. So yes, this case is a very real case. Yes, this case is ongoing. I do not expect a settlement at any point in the very near future. I personally can't wait until this case is closed, and hopefully they don't close the record on this, seal the record on this, because I would love to get my hands on these documents, specifically these questions that they're asking. I don't know if that'll ever happen, but it's my hope anyways. I'm going to end the video on that note. Thanks for watching. I appreciate your time. You guys have a great day.